Hi, my name's Sankaran. I'm a lawyer with Stewart Sharma Harsanyi law firm in Calgary. We specialize in practicing immigration law. Today I want to speak with you about the most common problems clients come to us with when they come to our office seeking immigration advice. One of the most common questions or problems we are faced with when clients come to see us is the question of how an individual can stay in Canada either permanently or on a longer-term temporary basis as a worker or a student. And often the people asking us these questions have visitor status in Canada. And we generally answer this question in the same way. The first thing we need to know is, what is the person concerned's work experience and educational background? Depending on that work experience or educational background, the individual may very well have an option to immigrate to Canada permanently. Right now, that option would be under the Federal Skilled Worker Program. That program is due to change in January 2015 and become what's called the Express Entry Program. There are no details on the Express Entry Program at this time, so if you are interested in pursuing an option like this, I would stay tuned or book a consultation with us in early January. The other longer-term temporary options are for an individual to apply for either a work permit or a study permit. In most cases, a work permit will only be issued if the person concerned has a labor market impact assessment, which is a validated job offer issued to an employer confirming that Service Canada has found the job offer to have a neutral or positive impact on the Canadian labor market. There are many processes and procedures in place to having to get a labor market impact assessment. If you have a job offer and want to know how to get a labor impact market assessment, then again, I would suggest you call our office to meet with us, because this is now a very complicated process. There could be other options for obtaining a work permit. Some options are under international free trade agreements. Some options are for people who are being transferred within companies. Again, if you have a job offer, then further steps would need to be taken before you could get a work permit and be allowed to work in Canada. And after obtaining a work permit, depending on the skill level of the job, you again may have many different options for permanent residence in Canada. In terms of obtaining a study permit, the individual concerned would need to get admission to a Canadian institution, be in a position to show that they have the funds to care for themselves or have the support of friends or family to help support themselves while in Canada, and that they have genuine student intentions while in Canada. Depending on the institution and the type of program, this could lead to a path to permanent residence as well. If you are here as a visitor, please be aware that you cannot simply file to become a worker or a student through an in-Canada process. Such applications need to be made at a port of entry in certain cases, especially in cases of work permits for visa-exempt individuals, or at visa offices abroad, which is the normal course for individuals who require a visa to come to Canada. In any event, if you're someone who's interested in remaining in Canada and you're here on visitor status, further, your circumstances need to be reviewed very closely to determine whether you have a direct path to permanent residence or whether a worker or student option is a possibility for you and a permanent residence application can be made subsequent to this. Another common question we get from individuals who come to see us is persons with worker status in Canada and how they might extend their worker status. Now, as mentioned, the labor market impact assessment process is the most normal way for individuals to extend work permits. If, for example, you're here on a 2-year work permit and your work permit's expiring, you need to be in touch with your employer and to ensure that your employer is taking the steps to get another labor market impact assessment for you. Now, the labor market impact assessment, or LMIA process, has become much more rigorous since summer of 2014, and we expect it will continue to be so for the foreseeable future. Some employers are more aware of the changes and the processes in place, while others are not. So if you or your employer are unaware of how the new changes affect your ability to get an LMIA, again, I would suggest calling our office so we can set up a time to go over those new procedures and new processes with you. The LMIA process is complicated and, again, has become more rigorous. Therefore, in most cases, if there's an option to extend a work permit without obtaining an LMIA, then that is the option we will try to seek for our clients. In the past, one very normal method of gaining the ability to extend your work permit was to get a provincial nomination certificate. In Alberta, this was a preferable option for both applicants and employers because the processing times for obtaining such nominations was 6 to 8 weeks or 8 to 12 weeks. Those processing times have now changed. The processing times are now 8 to 12 months. So if you're relying on a nomination to extend your work permit in the absence of an LMIA, then you need to ensure your timelines are in accordance with those new processing times. Other ways of extending your work permit could include if you have received a certain level of approval on a permanent residence application. For example, if you've received an eligibility notification under a Canadian Experience Class application, you can use that notification while in the last 4 months of your current work permit to extend your work permit for 1 year. The benefit of this is that, again, you do not require an LMIA, and the work permit that will be issued to you will be an open work permit for a period of 1 year. The theory behind this being, if you're going to become a permanent resident anyways, the government wants to give you the flexibility to choose your own employer and not have your employer have to get an LMIA, given that you've already found to be eligible under this class of permanent residents. You could also potentially do this under a federal skilled worker application as well, if you've reached a certain level of processing. Other possibilities could be LMIA exempt categories. Again, you need to look at that on a case-by-case basis, see if perhaps an international trade agreement applied or some other pilot project was in place to allow you to obtain a work permit based on a job offer rather than having to obtain an LMIA opinion. We often have clients come to see us when in fact they have exhausted most of their options for remaining in Canada, whether that is by their visitor status expiring or their work permit status having expired. And in such cases where applicants have no status, this is a common problem and the solutions are imperfect, to say the least. If your status is expired and you are within the 90-day period after the expiry of your status or notification your status is expired, then you could apply to restore your status. Of course, you need to be eligible under the category under which you apply for restoration. For example, if you want to apply to restore yourself as a worker, on most occasions you need an LMIA to append to that application, otherwise you will not get the restoration as a worker. Similarly, as a student, you need to meet the student requirements and so on for a visitor. If you are beyond the 90 days and want to remain in Canada, your options become very slim. And any counsel who tells you otherwise is selling you something you don't want to buy. Because if you're past the 90 days and you're not married to a Canadian and cannot file a spousal sponsorship, you're left with essentially a couple of options. Go home, which is an option that's always available to a foreign national, but is usually not the preferable option. Apply for what's called a temporary resident permit, which is a special authorization from the government that's issued to persons who can show exceptional circumstances or reasons why they should be allowed to remain here. Temporary resident permits, or TRPs, are an option. They're on the table. However, the issuance of TRPs is only reserved for the most exceptional of circumstances. So again, you need to weigh the possibility of getting TRP with the risk of further enforcement action being taken against you. Because if you are someone outside of the 90-day period, then immigration enforcement, or the CBSA, can take steps to remove you from Canada. Whether they do or not really is based on their workload, but you need to be aware there are risks of remaining in Canada, as well as potential benefits if you can obtain a TRP for remaining well beyond the period authorized. In terms of permanent residence possibilities, again, in very exceptional circumstances, where a spousal sponsorship is not a possibility, you're always free to file a humanitarian and compassionate application. Again, these permanent residence applications are only issued in the most exceptional of cases where you can show undue, undeserved, or disproportionate hardship if you had to return to your country of origin. Finally, usually in most cases, a refugee claim is a possibility. Again, this possibility would only be reserved for people who face some risk to their life or have a well-founded fear of persecution based on race, politics, social class, or being part of a group or other enumerated grounds if they return to their home country. This could apply, again, this could apply on a case-by-case basis. You would need to review your own circumstances, obviously, to determine if this is a viable option for you. We do often run into a very common problem of clients who come to us where they have no status in Canada, but they have married a Canadian citizen or permanent resident. And oftentimes, these clients are confused as to what their options are in Canada. If you are married to a Canadian citizen or permanent resident, and you have no inadmissibilities, but you have no status in Canada. And what I mean by no inadmissibilities is you have no criminal inadmissibility or other sort of inadmissibility, such as being found to be a member of a criminal organization or a terrorist group, which is not going to apply in most cases. Then your lack of status can be overcome through an in-Canada sponsorship by your partner. Now, the processing times for such sponsorship are quite long. Nevertheless, if this type of application is filed on a timely basis, namely prior to when a PRA interview is convened for you in the enforcement process, then in most cases, you can usually remain in Canada while this is in process. Sometimes this will become a timing issue based on when the PRA interview was convened and when the sponsorship was filed. Sometimes this is going to be based on how fast CBSA enforcement is moving to remove, for example, failed refugee claimants. But the bottom line is this: don't think lack of status is the be-all, end-all impediment to you remaining in Canada if you are married to a Canadian citizen or permanent resident. Their sponsorship, in many cases, can overcome this issue, and therefore you should not wait or hesitate to file such a sponsorship. In almost all cases, in our experience, as long as there are no other inadmissibilities, CBSA or immigration enforcement will usually not take action on your file. You will eventually be issued a work permit when first stage approval is granted, and then PR will be confirmed sometime down the road. So please do not use your lack of status as a reason not to file an in-Canada spousal sponsorship. Finally, we often have clients who are foreign nationals come to our office who query about the effect of having a Canadian child has on their status in Canada. Some individuals believe having a Canadian child confers an automatic status in Canada. It does not. In fact, having a Canadian child, especially a Canadian minor child, really does not offer that many options for status in Canada. When the child becomes of age and has worked long enough in Canada, they can sponsor foreign national parents, provided they meet certain income requirements. But please do not automatically think that if you have a Canadian child, this will sort out your immigration or status problems in Canada. On another note, the Canadian government is studying the issue of what's called birth tourism, meaning it hasn't been properly defined by the government, but what it refers to is the practice of pregnant mothers coming to Canada, having their child on Canadian soil, and therefore having Canadian citizenship conferred on their child while they have no real ties to Canada. Nothing has been done legally or legislatively to actually address this issue. It is being studied, but again, if you believe this is a concern for you or want to be updated on the latest, then by all means contact our office and we can advise you as to the current state of the law with respect to this issue.